Process, winner of 15 New York and Mid-Atlantic Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights.
I don't know how this court can decide that one life is worth less than the other. Certainly not to the victims' families and friends.
Driving while intoxicated. If a death's involved, you could lose lots more than your license. It could be your freedom. The sentence for this man, 40 years. The increasingly serious consequences of drunk driving on this edition of Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law. And by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by the PSCG Foundation and the Thomas and Agnes Carvel Foundation.
Drinking and driving, a potentially lethal combination. There's nothing new about that notion, but what may be new is how the justice system is responding, especially when it leads to the loss of life. I'm Raymond Brown, and on this edition of Due Process, the questions raised by a recent 40-year sentence imposed on an admitted alcoholic who drove drunk and killed two young cousins, pedestrians on a Morris County road. We'll talk to one lawyer who was himself almost killed by a drunk driver, and to another who's defended death by auto DWIs. Their divergent views of the new, tougher sentencing coming up. But first, Sandy King with the story of that tragic Morris County case. Sandy?
Raymond, it's a story that started with a walk to the movies and ended with what amounts to a virtual life sentence. A milestone, and another example of an apparent dichotomy of American life. On one hand, an increasing intolerance of drunk driving. On the other, a society in which a couple of cocktails and a bottle of wine are still considered part of a normal night out, even if you're driving home. But it was one extreme drinker and the fatal result of his impaired driving that were on the judge's mind in that Morris County courtroom.
I could not ignore the fact that there are two young women who will no longer be able to share even the most basic things in life.
With this, thank God, they can rest in peace, my daughter and my niece.
They were cousins and best friends. High school sophomores with big ambitions. Mayada to be a lawyer, Athir, a pediatrician.
No sentences or punishment will bring my daughters back. My life and my family are forever damaged.
They had been walking to the movies early evening, April 20, 2006, when the unthinkable appeared in the form of Eugene Baum, driving drunk on the shoulder of this Kinnelon road.
My sister's killer may not remember the day he drank himself into the accident that changed my life, but I want him to remember now, sober, the heartbreak and the devastation he has caused my family.
A jury had already ensured Baum would pay for that pain, but the sentence would be up to this judge, who voiced his own judgment and his disgust.
Mr. Baum, your excessive drinking inevitably made you a harbinger of death. A harbinger of death.
While Baum spoke directly to the families.
For with my power, I would change places with them and restore everything they used to do. But I cannot. I'll forever live with the guilt and remorse of taking the lives of your daughters.
But that expression of remorse was not enough to keep Judge Salem Otto from handing down what may be the toughest sentence for DUI homicide, one not in conjunction with another crime in progress, that's ever been imposed in this state.
I don't know how this court can decide that one life is worth less than the other. Certainly not to the victims' families and friends.
And that meant consecutive sentences, not concurrent. 20 years in prison for each of the cousins, 40 years in all, at least 34 of which must be served. And that for a man who is nearly 50. Have you ever seen a case where someone received this kind of time?
Not to my immediate memory, certainly not in any of the matters that I've handled.
And Baum's lawyer wasn't the only one who thought the sentence hit a new high. The state doesn't keep those kinds of records, but of all the DUI attorneys and prosecutors to whom we spoke, not one could cite so long a sentence for the taking of even multiple lives while driving drunk. So you think it does send a message?
I hope so. And I would like to have a legislation even under my daughter's name. Whatever who drink and drive and kill somebody, no bail, lifetime in jail. Let the family go on in life.
If you ask a DWI victim's family, there is not enough of a punishment that can be given to a DWI offender, especially if they lose one of their relatives. And the amount of damage and destruction that's done to a family because of one DWI offender is overwhelming.
And more than 20 years ago, Steve Benvenisti was a pedestrian victim himself, barely escaping death and forced to fight his way back from devastating injuries.
Unfortunately, the driver in my case was not severely prosecuted. My accident happened 20 years ago. It happened in the state of Florida. The laws in the state of Florida were not written as well as the laws are written in New Jersey today.
I obviously don't agree with the jury verdict, which put us in this position. The defense of diminished capacity, I think, was applicable in this case. That was effectively knocked out of the box.
But Baum had been offered a plea deal and rejected it. You could have had a bargain for 20 years.
Yes.
You rejected it?
Yes.
Because it was too long a sentence?
Yes.
But the plea deal would have given Baum the chance of freedom instead of what amounts to a virtual life sentence.
I felt bad for Eugene Baum's family, his mom and his sister, you know.
We feel free.
Yeah, we feel you too.
He destroyed 3 families, not only my and my brother-in-law family. He destroyed his own family too.
But you feel that you have gotten justice?
Yes, yes, yes.
So the victims' families felt they'd found some justice, and Eugene Baum was on his way to state prison. But an appeal was already in the making. As we heard from Baum's attorney in that tape piece, the defense contends that their strongest weapons, the arguments that Baum was ill, out of control, not aware of what he was doing, not responsible for his actions, had been taken away in pretrial rulings before a jury was ever impaneled. Whether an appellate court will ultimately agree won't change the fact that a 40-year sentence, Raymond, has raised the stakes on DWI.
Is that good public policy? Is it fair and equitable? Two very different takes on those questions when we return, so stay with us.
You know, something close to zero tolerance is good. You know, in terms of harsh punishments, I think people should not get off with just a fine. I think jail time is appropriate.
If the time fits or the penalty fits the first time, then maybe people wake up and you won't have so much repeat offenders out there.
I think criminal penalties should be imposed because people are getting killed needlessly.
They have to crack down on it, but I don't think like the first time should be such a harsh sentence.
I think people need to be aware of the fact that their actions have implications for the rest of society, and going out and driving drunk is a pretty dangerous and foolish thing to do.
That virtual life sentence imposed on Eugene Baum has drawn doubt in some quarters, cheers in others, and that's reflected in our two guests. Robert Bonney is a former prosecutor, now on the defense side. He's past president of the Association of Criminal Defense Lawyers, and his caseload includes DWI deaths. Stephen Benvenisti, whom we met in Sandy's package, also does DWI, but on the civil side as a plaintiff's attorney, and always in the shadow of the accident that almost killed him. Gentlemen, welcome to you both.
Thank you, Ray.
Bob, let me start with you. You and I have both practiced criminal law in the state for a long time between the two of us. Does a 40-year sentence for 2 deaths involving 2 innocent people who did not provoke it in any way, but with a man who has no prior records as the defendant, does that surprise you? Does it seem excessive?
I think that the case involves specific facts that led the judge to do what he did. The policy of the code in sentencing is to let the punishment fit the crime, not the criminal. And in the case of consecutive sentences, there's the policy of no free crimes.
You mean 20 on top of 20?
20 on top of 20. The question here, though, is that ordinarily you have consecutive sentences that follow crimes that occur on different dates, different victims, different events. Here, it is one aberrant behavior, one course of aberrant behavior that results...
And let me ask you to think as a legislator.
All right.
If you're a legislator and you see that a guy with no priors, no prior convictions, but also with these 2 victims, would it be your thought that that's the kind of sentence you ought to signal to judges you think is too much, or do you think it's too little? Because it is a huge sentence, it's the rest of his life. On the other hand, the family, as you saw, felt it was almost just.
Well, I feel that the legislature should allow the judges to do their job and not impose mandatory minimum sentences.
Talking, Bob.
Yes, it is. So the question is, you know, in exercising his discretion, was the judge over the top, beyond what was reasonable under the circumstances? It's a close call. You're dealing with a situation in which there's an unusual risk to the public when you have a person who is an alcoholic and has been involved with alcohol and abused alcohol, albeit no priors. But nevertheless, the evidence in this case, as I understand it, involves someone who has abused alcohol continuously.
Could I say you think it's high but within the range of reason, although the appellate division may look different?
I think that's fair.
Right. Steve, Sandy, as she noted in her report, has called around the state, talked to prosecutors, defense lawyers in every county, and the sense is that while nobody remembers a sentence like this for this kind of case where it's isolated and not part of a crime spree, for example, there is a sense that penalties in criminal cases where alcohol has been the cause of a death are rising. Is that good public policy from your point of view? And are there limits? Is 40, for example, for this guy enough, too much, or at the outer limits?
Well, I believe it's good public policy to begin with. And it's very hard for me to find sympathy for this criminal defendant who probably learned as early as high school that if you consume alcohol and then you get behind the wheel of a car, you really are a harbinger of death, as Judge Salem put it. My perspective as an attorney who represents victims of DWI, it's unfortunate that I don't get to meet most of my DWI victim clients because they die so unnecessarily in these completely preventable accidents. But I get to meet every single one of their families. And you hear about 40 years for this particular defendant. But I think about the 2 young ladies who passed away, how each one of them probably had a life expectancy of an additional 50 years for each one of them. And what about the kids that they would have had? And all the damages that went on in those particular cases. And what about the mother, the father, the relatives who have to go on for the rest of their lives with a tremendous and overwhelming amount of pain because of this one defendant's selfish actions on that particular occasion?
Bob, and I don't want to get too much into the technical part of this, but in fact, if he had done one purposeful killing, one killing that was sober but deliberate, he'd have 30 years, yes, and that would be life.
That would be true.
Or close to life at his age. So is there a sense of imbalance that 2 killings that take place not because of deliberate conduct, but because of a extraordinarily high degree of recklessness, gets him in the same range or even higher?
That is how it has worked, I think, in this case. You know, the other charge that he had was aggravated manslaughter, which does involve a situation in which you've acted with extreme indifference to human life. And that sentence and the max in that particular statute is 30 years. So the judge didn't do the max, but he got very close.
If I may just... I understand why lawyers say that it may not have been a crime of intent and maybe it wasn't a deliberate act, but if you ask anyone, they'll tell you that no one had a gun to his head when he had his first drink, and when he had his second drink, and his third drink, and then he became intoxicated. And then he made the deliberate act of looking at his car keys and getting behind the wheel of his car. Those were all intentional acts.
I want to come back to that when we talk about what the defense was. Before we do that, I thought there's something that the viewers should know a little bit about with respect to your life. And while you're talking about it, that is describing the results of your own terrible tragedy where you were hit by a drunk driver. Sandy's going to show some pictures that relate to that. So if you could give us a quick summary. I know it's complex to
No
be quick
problem.
about.
When I was 21 years old, I was attending the College of New Jersey, formerly known as Trenton State College. I was out with my friends. It was spring break. I wasn't drinking. I was walking. And a repeat offender, drunk driver, lost control of his vehicle. His car came directly at us. His lights were off. Fortunately, he didn't strike my friends, but he struck me. The vehicle crushed my legs upon impact. People in the area had woken up who were sleeping because they heard an explosion. And that explosion was the sound of my head smashing through the outside windshield of his car. I remained in the hospital for 6 months.
Did you have extensive brain damage?
Well, they call it a severe traumatic brain injury, and yes, I did. I had extensive severe traumatic brain injuries to my brain's frontal lobe, my cortex, my brain stem. I had massive swelling as well to my brain. I had horrible orthopedic injuries. I underwent 15 major surgeries.
Now, one of the things you told me before we went on the air was that the guy who hit you got no sentence at all.
Unfortunately, the law as it was written in Florida at the time didn't lend itself to giving him a sentence that was appropriate. In addition to that, it was very difficult.
What do you think would have been appropriate?
Well, if I may just finish that thought. All of the witnesses at the time were spring breakers from all around the country, and they were drinking alcohol, but they weren't operating motor vehicles. And my family at the time wasn't putting a lot of pressure on the prosecution to prosecute this defendant because the main focus was my surviving the accident.
But given all of your experience, what do you now think, given the experience and the exposure you've had to this issue, from a public policy point of view, would be an appropriate range of sentence for that guy?
The guy who struck me?
Struck you.
Well, obviously I'm biased because I know what I've been through, and that's why a court can have more of a level head when issuing sentence. But I know that I went through many years of emotional trauma, and even though I am quote-unquote better right now, my family still experiences emotional trauma related to my particular accident.
Bob, let me come back to something that we started to wander into. The defendant in this case tried to argue that he should be allowed to defend by saying he was an alcoholic, which I think was undisputed. And because he was an alcoholic, he couldn't stop drinking, and he should be allowed to defend by saying he was, in a sense, compelled to drink or unable to control it. We also have a law that says if you voluntarily take alcohol, you can't say that the alcohol relieves you from responsibility in a case like this.
It's very true.
Are you surprised that that defense was offered, and do you think the higher courts are going to say he should have been allowed to offer that defense?
Well, I, as you know, was not there and did not follow all of the aspects of the case, but the statute, in terms of intoxication as a defense, says that you cannot use the alcoholism as a basis for a mental defect defense, that is, diminished capacity or insanity. And so given what the statute says on its face, I have some question about whether that aspect of the appeal will succeed. The sentence, of course, is a different issue.
But Steve, isn't there a little disparity? I mean, everybody concedes, I think, in the medical world that alcoholism is a disease. That diseased behavior can cause people to be out of control. What I thought I heard you say earlier was, yeah, but he made the decision not to drink, which maybe you couldn't control, but he made the decision to have a car and to drive, and that's the decision should be punished. Does that mean that in some areas the law has to put medicine aside and say, we just won't tolerate this behavior even if driven by some compulsion and can't be controlled?
Absolutely, because if you think about any felony that's committed, what they all have in common is that a criminal defendant at some point made a decision, and made a decision that was selfish, made a decision that they knew at some level put other people's lives at risk. And certainly for someone who's had a drinking problem for years, is aware of the fact that there's a risk when you get behind the wheel of a car that now you're not only putting your life at danger, but you're putting the lives of innocent people at danger as well. So,
let me ask you, from a policy point of view, would you think these sentences should be the same if there was no alcohol involved in this case? If he had veered off the highway just being reckless, or as opposed to driving drunk in the lane in which they were?
No, I think under those circumstances the sentences should be lighter.
And why?
Well, because once again, when it comes to consuming alcohol, we learn at a very young age that if you consume alcohol, your reflexes, your judgment, your coordination, everything is going to be impaired.
So if you're texting and you produce the same result, you think as a matter of policy that should be treated differently than this kind of alcohol-related event?
I think, and the law allows the judges to consider every single case on an individual basis, and there are so many other factors that the judge even considered in the Baum case, and that they consider in every other case when they issue a sentence.
Right.
And there's if I may add, there's an added protective mechanism for all criminal defendants, that there's an appellate division and there's a state Supreme Court, and if the judge was extreme in his sentence, then that can be adjusted accordingly.
One of the concerns is that NERA, the No Early Release Act, the 85% rule, applies to vehicular homicide regardless of whether or not alcohol is involved in the accident or not. Another example, in our view, that the mandatory minimums in tying the judge's hands, not giving him the discretion in various cases to pass in a sentence, is something that actually holds back a just result in many cases because the judge's hands are tied. It's easy to look at the Baum case and say this is an aberration, this is horrible beyond description in terms of the problem. But there are closer cases where the person has a .08 or less and there's death involved. And those cases are more difficult from a sentencing standpoint.
Now, the legislature is continuing to struggle with this issue. And it's looking at maybe some other ways of keeping people from driving when they're drunk, since there can't apparently be a solution where everybody gets locked up. So if we can't lock up all the defenders, then how to keep them off the road and the rest of us out of harm's way when they're drinking. Well, as Sandy reports, the state's just instituted one technique named for this mother's son.
Yes, he had 3 prior convictions of DWIs plus motor vehicle accidents. So his 4th one, he ended up killing someone, which unfortunately was our child, Ricky Jr.
He was riding his bike when the drunk driver hit and killed him. So the new law requiring some DWI offenders to install a kind of breathalyzer in their cars carries Ricky's name.
It's worked in other states, it's been effective, and all it's asking of the drunk driver is, who's been convicted, is to not drink and drive again, to not drive again while intoxicated.
It's designed to keep them off the road if they've been drinking. .08. And it works like this.
Now let's begin. Turn on your ignition and the system will say, please wait.
Please wait.
After a few seconds of warm-up, the determinator will say, please provide a sample.
Under Richie's law, the device requires a breath sample every time the offenders start their cars. If they're well above the legal limit, their ignition will lock.
I know it'll keep the drunks off the road, which will make it another family not have to go through the tragedy that we have to go through every single day of our lives.
Steve, is this device an admission that there really is an involuntary nature to this problem, but also isn't it something that's going to be easily circumvented?
I think if the device has in it the potential for people to break the law by having others blow into it, that those issues can be dealt with separately. The bottom line is this device has been instituted in states throughout the nation, and the CDC has already determined that rearrest rates have declined by more than 70%. So we already know that this device has prevented accidents. We already know that this device has saved many lives.
Bob, do you agree that this is a useful device? And also, does this raise the fact that we're not dealing straightforwardly with the nature of this disease and how that affects voluntary behavior?
I think we're dealing with reality with this device. The concern, however, is in its application. The statutes that have recently been passed to implement it here in New Jersey went into effect in January, and cases down the road will be affected. But the cost of this unit is not inexpensive, and you have to have it retested, and if you cannot afford to have the unit, then you cannot get your license back. These are issues that the legislature is going to have to wrestle with going forward.
So there may be a class bias inherent. Or
exactly.
At least how do you feel about, Steve, the fact that there are other policy questions like equal protection for poor folks that are going to get cranked into this debate?
That's why we elect our legislators to make those decisions. And each and every one of those defendants found the funds necessary to defend themselves in criminal court. And all this is asking is for those particular defendants who had a blood alcohol content that's twice the legal limit, is that they should pay out of their own pocket to install this device, and by doing that, you're going to be protecting the people on the roadways, and that's of prime importance.
Bob, I don't want to call you an old-timer, but you've been around long enough to see a significant change in how the courts and the public regard the issue of drunk driving. 10 to 15 years from now, do you think we'll still be wrestling with this as a major public policy problem, or do you think there will be enough fixes, mechanical and otherwise, that we won't be?
No, I see it. The issues we're wrestling with right now are going to continue, and the increasing of the penalties that have been associated with driving and certainly vehicular homicide are fully understandable under the circumstances.
Steve, in 10 seconds, are you optimistic or not that we'll have such a significant attack on this problem that 10 years from now we won't have to wrestle with it like this?
I'm optimistic because since Mothers Against Drunk Driving was founded in 1980, the statistics for DWI deaths have gone down by almost 50%. Education in school now is so much.
In 10 years and test your thesis. At the moment, I just want to thank Bob Bonney and Steve Benvenisti for taking on an issue without easy answers, the kind we like best here on Due Process. That's it for this edition, but we'll be back next week and every week with more on law and justice. Till then, for Sandy King and all of us here at Due Process, I'm Raymond Brown. Thanks for watching.
My wish for you is that each day, from the time you open your eyes in the morning till you close them again at night, and even in your dreams, you remember my sister's face, her beauty and her uniqueness that you took from this earth. I also hope you feel the pain and sadness for my family's loss that you have created. No person, especially Mayada and my cousin Afir, deserves to have their lives ripped away from them so young and innocent. To all those in this courtroom today, especially Judge Otto, I hope that it is clear that no sentence will ever bring my sister back, but our lives will forever be tampered and broken, which is why I feel this man's life should be no different.
Major funding for due process provided by the New Jersey State Bar Foundation, committed to educating the public about the law. And by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by the PSCG Foundation and the Thomas and Agnes Carvel Foundation.